I feel like I have courage and can speak out is because David, he's like, why don't people just say how they feel? And why can't, what's hard about a conversation? He didn't understand.
Okay, my friends, my besties, it's Sophia. And today we have to discuss something serious about Ysabel Brown and a lawsuit she's got going on in Utah. Some of you may be asking yourselves why we would do stories on legal cases pertaining to reality television personalities, but that's precisely what we do here. On this channel, we discuss everything Sister Wives related, legal or not, when talking about the individuals involved with the show. You probably recall, I once discussed a lawsuit in which Mr. Peyton Brown was being sued by two women in Nevada. This case with Ysabel is no different in theory, yet the situation is particular. This specific suit is the result of an incident that occurred a few years ago. I know, of course, that some of you in the comments have questioned this whole situation, asking if perhaps this isn't all on the up. Some went so far as to question whether the litigant might be suing Ysabel simply because her mother appears on a reality show and thus could have deeper pockets. Regardless of the speculation, Ysabel was legally obligated to respond, and she has. Not only that, she's fighting back and has officially requested a jury trial. That's an important takeaway. If you're ever sued, hire a lawyer immediately, and that's exactly what Ysabel did. This scenario is unfolding in the state of Utah, where the plaintiff asserts that a couple of years ago, she and Ysabel were both driving on a very congested stretch of road. Ysabel was allegedly driving too fast and tailgating, the allegations state. Then, at rush hour, when traffic suddenly stopped, she allegedly rear-ended the car in front of her. That collision allegedly triggered a ripple effect, one vehicle colliding with another. Which collided with another, that included the plaintiff. The plaintiff asserts she incurred significant harm, such as loss of enjoyment of life. Now, audience reactions have been divided. Some of you jumped to the conclusion that the claims must have been opportunistic, particularly because the accident was years old, and others feel that if the events occurred as set out, Ysabel should be held liable. Ysabel's reply, however, presents a very tactical legal defense. Her first defense. She claims the plaintiff's complaint is deficient in stating a claim on which relief can be granted. She's not necessarily filing a motion to dismiss, but she's responding point by point to the allegations. Ysabel concedes some of the details, but not all of them, and in some instances, says simply that she doesn't have sufficient information to admit or deny the allegations. For instance, Ysabel confesses she owned a valid driver's license, took driver's education, knew safety legislation, and was operating a car on the I-15 at the same time and location as the plaintiff. However, she refuses particular facts regarding the order of vehicles. In the plaintiff's version, directly behind her was a car driven by someone named Emthus Vera Yenido, with another driver named Jawat Marai behind them, and Ysabel's Honda HR-V behind Marai's vehicle. Ysabel disputes this arrangement, claiming she doesn't know whether those people or vehicles were actually involved. Interestingly enough, she does acknowledge she rear-ended the car in front of her, which resulted in the crash. When, however, the complaint alleges that the other vehicles came to a stop and that Ysabel's not doing so resulted in the accident. She neither admits nor denies it. She does agree the collision occurred but states she does not have sufficient knowledge to concur in the plaintiff's account regarding speed, control, or sequence of events. The plaintiff further claims that Ysabel's negligence actively precipitated the chain reaction crash, but Ysabel counters that she lacks sufficient evidence to substantiate those claims. In her formal court answer, she denies all the other claims not specifically admitted or addressed. In short, Ysabel is holding firm, disputing as much as she can, and allowing the court to adjudicate the rest. O. Essentially speaking, the plaintiff is accusing Ysabel of being negligent and causing the accident, leading to injuries. More than $3,000 damages, physical and mental suffering, and a loss of lifestyle enjoyment. Ysabel denies any responsibility for all that, and in truth, when someone's suing you, denial can be one of your best defense options. The actual problem here is that, without a full crash investigation, and it's not even clear if there is one, establishing fault might be tricky. In her defense, Ysabel contends that any damage or injuries the plaintiff incurred might have been caused, at least partially, by other individuals whose conduct she has no legal obligation to prevent. She's actually asking that any such drivers be enumerated on the special verdict form so fault can be allocated evenly. That means that her team would likely make the argument that she perhaps rear-ended one car but wasn't responsible for the next car rear-ending the car in front of it, or for the chain reaction continuing until hitting the plaintiff. Now, it gets tricky. If all three cars in front were completely stopped, could Ysabel's impact really have pushed all of them forward into one another? Or did some of them move on their own? I'm not a crash reconstruction expert, but those questions matter. Ysabel's position is that each driver's behavior should be measured against the others in order to ascertain how much, if any, blame she should take, and damages divided accordingly. She's also building a case that evidence can prove the plaintiff did not mitigate her damages. For instance, if the plaintiff was not wearing a seatbelt, didn't have airbags, or responded in a manner that exacerbated the accident, such as braking too hard, those facts allow for blame shifting. This strategy allows for the argument that even if Ysabel was responsible, others were at fault as well. Another argument Ysabel has is that the plaintiff might have already collected personal injury protection PIP benefits from her own insurance company. If that's the case, Ysabel's lawyers want any payment made by the plaintiff's insurance subtracted from any potential court award. Essentially, if her medical bills are already paid for, Ysabel shouldn't have to double pay for them. What's bewildering is that the plaintiff failed to go directly to Ysabel's insurance firm. In most such cases, insurers settle disputes among themselves, not battle it out in court between two drivers. Ysabel has also left open the option of adding additional defenses as additional evidence emerges. Ultimately, she's requesting a ruling of no cause of action, basically, for the court to reject the claim outright, plus her legal fees and any other relief that seems equitable. And here's where Utah law comes in, big time. Utah is among a handful of states with a no-fault car insurance system. This implies that regardless of who is responsible, your own policy pays for your medical expenses and lost earnings to a predetermined amount. In Utah, drivers are required to have at least $3,000 in PIP coverage. This coverage covers medical bills, loss of income, and even funeral expenses in the event of death. But it does not cover pain and suffering. But there is one legal way to go outside the no-fault system, as Nolo.com explains. In order to sue the at-fault driver directly in Utah, you have to meet some requirements. First, you have to have incurred at least $3,000 of medical expenses due to the accident. Second, your injury has to qualify as a serious injury, which means permanent disability, permanent impairment, permanent disfigurement, or dismemberment. If you meet these criteria, you can then file a third-party claim or personal injury suit for pain, suffering, and other non-monetary damages. That's why it's interesting that this plaintiff didn't go straight to Ysabel's insurance company. If the case meets the legal thresholds, there would be a direct path for a claim there, but instead, we're seeing this unfold as a lawsuit in court. And that, my friends, is where things start to get very, very interesting. Perhaps she did try to go through her insurance and was then denied. I don't know for sure. But the key point most people aren't aware of is this. In Utah, due to how the insurance system is structured, you can't recover financial reimbursement for pain, suffering, or other monetary damages that aren't tangible through your own insurance policy. It doesn't matter how much you feel you've been hurt. If you're looking only at your own policy, you'll only get a limited payout. You want more than that, particularly a big settlement. You need to go totally beyond your policy and sue the third party yourself. That's the only option. And that's why it's so odd and really so suspicious that this lawsuit is being brought more than 2 years after the initial incident. Most folks don't wait that long unless there's a very good reason. What else makes this whole thing stand out is how unbelievably vague the lawsuit itself actually is. Typically, when something like this is brought, it's loaded with details. You'll see the exact date of the accident. You'll see a timeline of what happened. You'll see specifics about the location, the sequence of events, and copies of supporting evidence like an official crash report or even a traffic citation. All of that helps establish credibility. But in this case, none of that exists in the filing. They didn't attach a single piece of physical evidence. No crash report, no ticket, nothing. And here's what's even odder. The plaintiff never once simply tells us what her injury really was. She only wrote that she incurred bodily injuries, some of which may be permanent. Now, that language is really key. In Utah, the statute has a strict legal requirement for these types of personal injury cases. If the injuries are temporary, or they don't result in permanent impairment or permanent disability, the claim might not even be eligible to proceed in court. And come on, after 2 whole years, most of us already know whether or not our injury is permanent, a brain injury, a spinal cord injury of some severity, something to alter your life for the rest of it. Such consequences are fairly clear-cut before all this time has elapsed. Maybe permanent does not ring terribly confident to me and makes a big fat area for Ysabel's lawyers to attack the validity of the claim. In addition to that, Ysabel is well within her rights to ask the court to determine if the plaintiff herself was abiding by the law when she got into the accident. Consider it if she was speeding, then jerked to a halt even though still traveling too fast. It could make it nearly impossible for the other drivers behind her to avoid in time in a safe manner. And if that can be substantiated with facts, Ysabel can be fully exonerated of blame. And besides, this wasn't even a two-car collision, other cars were allegedly involved. So the facts about each driver's speed, location on the road, and reaction time are all relevant. A proper accident report would inform us of those details. But again, none of that has been annexed to the lawsuit. And that's why Ysabel has every right to battle back. Utah has an extremely high standard of winning cases such as this. Just because somebody points the finger at you doesn't necessarily mean you're legally liable. And just because they say they got hurt due to you doesn't necessarily mean you're responsible. Car accident fault isn't straightforward, it's an application of physics, legal precedent, and verifiable evidence. And one thing is perfectly clear here. The plaintiff could have, and likely should have, approached Ysabel's insurance company directly to begin with rather than bringing a vague suit. Let's also keep in mind that all drivers in Utah are required by law to have car insurance, and there's no charge here that Ysabel was driving without insurance. That alone gives rise to some doubts. If both drivers were insured, and if there was actually an injury, this issue could and should have been resolved between both insurance companies without ever entering a courtroom. That is how most people do it, which makes it even more rational that Ysabel would question why it is being done that way now, particularly after all these years. Examining the actual complaint, there are enormous gaps. No details on the injury. No documentation of any medical bills. No crash report to confirm the chronology of events. That's not how solid, winnable cases are constructed. That's why Ysabel is basically holding firm and saying, you haven't disclosed to me what your actual injuries are. You haven't produced the bills you say you have. You haven't even provided me with evidence that the crash occurred the way you claim it did. So how can you possibly demand I take the blame? And rightfully so, too. I really am relieved that she has a good attorney representing her, because these kinds of cases have the potential to become total nightmares for defendants. They can last for months, even years, with huge financial outlays and anxiety, even if the defendant eventually prevails. And if the timing of this lawsuit has something to do with Ysabel's reality TV fame, that makes the entire situation all the more troubling. Because if someone is attempting to use her celebrity and perceived fortunes to secure a payoff, that's not only suspicious, that's strategic targeting. And the fact that it's exactly 2 years since the purported accident makes it even more difficult to dismiss that possibility. But that's just my own opinion on all of this. Now I want to hear yours. Is this a real case that simply happens to be vague, or is this an opportunistic money grab? Leave your thoughts in the comments below, because I am really interested to hear what you have to say. And while you're down there, don't forget to give a thumbs up button a click. It really does help support the channel. And if you haven't already, be sure to subscribe and hit the bell so you never miss one of our in-depth breakdowns.